Okay, so welcome everyone to the second tutorial for LAWS12070 on public international human rights law. And tonight we examine the topic on sources of international law. It is a very important topic, mainly because unlike, for example, if you want to talk about international law, you want to know what exactly is international law, what is the content of international law, how do you know what is international law? If you had examined this for the domestic legal systems, it is easy to know what the content is of domestic law because you have the chance of examining statutes which could be passed by a parliament or a legislature of a particular domestic legal system. You could examine cases or case law to determine again what the source, what the law might be on a particular subject. And therefore, there are various ways by which it is easy to determine what the content is of a domestic legal system. But when you speak of international law, given the fact that international law involves mainly as participants various states, and we know that various states have their own practices, they have their own domestic legal systems. In fact, if you examine, given the fact that the UK and Australia have a strong historical tie, and given the fact that Australia and New Zealand are geographically proximate to each other, and they also have strong international ties, and as well as historical ties, because for those of you who may not know, there was actually a time when, prior to the establishment of the Commonwealth in 1901, New Zealand had the opportunity to join the Commonwealth, but it did not. So it could have, New Zealand could have been part of the Australian Commonwealth, but New Zealand decided to embark on its own as an independent state. So if you examine, for example, therefore the various domestic legal systems, we know that the content of their laws are very different. And given the differences in terms of political systems, in other words, and in terms of democracies, issues of freedoms and rights, we know that some states probably are, provide more freedoms to their citizens, others don't. We know as well that there are different rules as to what civil obligations might be, different rules as to what crimes might be. And so therefore, it is difficult to determine oftentimes what exactly is the content of international law. So it's crucial therefore for us to know what the sources are of international law. And when you look at international law, therefore, one of the main limitations we have is that, unlike in domestic legal systems where the content of domestic laws mainly arise from the legislature, which conventionally is known to be that body in a legal system or in a political system that creates laws, there is no such body in international law. So for example, the United Nations and even the Security Council does not create international law. Wouldn't that be interesting? So even if there was a unanimity in the General Assembly of the United Nations, and they made statements which we would have thought that on the basis of what they said, that would have become a source of international law. We need to realize that the United Nations is not some form of international legislative body that creates laws for states. So that's one of the problems that we have. And we have a problem as well because, unlike, for example, in most domestic legal systems, so when you look at the common law, we know that there is the principle of stare decisis, so that decisions made by the High Court of Australia, for example, creates legal precedent, and it is binding not only in the High Court, but also especially in inferior courts. It binds all inferior courts in whatever decisions it makes. But when it comes therefore to the International Court of Justice, do the decisions of the International Court of Justice establish binding precedents so that there is such a thing as stare decisis? Because if that were true, it would actually mean that you have an International Court of Justice that might be superior to states themselves. So can you imagine if the International Court of Justice had the power to make legal precedents, make judgments on certain cases that then automatically bind all states. Can you imagine the power of the International Court of Justice? And you begin to wonder, is the International Court of Justice itself, is it a source of international law? Which means that anything it says, is covered by the principle of stare decisis, which is common in domestic legal systems, and therefore is binding upon all states. So these are questions that are important to examine when we look at sources of international law. So tonight, after studying this topic, you should be able to discuss and explain the legal basis for the binding character of international law and the sources of international law. Now, before I continue, would any of you happen to have any question? And feel free to unmute yourself.
Sorry.
Yes?
I was just quickly reading through the study guide for this week, particularly the point 2 of the binding character of international law, and I simply do not get, like, is it the Lotus case?
Yeah.
Or the Lotus case, and how Turkey tried to assert criminal jurisdiction over the French national, but then France said no, he's our business, he's nothing to do with you, and then the court said no, Turkey's got concurrent jurisdiction to prosecute him. Yes. And I kind of don't get it.
Okay. So when you look at the case of the Lotus case, which is a case of France versus Turkey, what Turkey had done was to actually assert criminal jurisdiction over a French citizen who was the officer of the watch on board the Lotus, which at the time collided with a Turkish vessel, and France objected to the assertion of jurisdiction by Turkey on the ground that in international law it is agreed that it is the state on whose flag is being flown in a particular vessel that actually has jurisdiction over that ship. That is part of customary international law. So that is recognized. Now, the point, however, of France was that because that is international law, it means therefore that it was binding on Turkey as well, which means that essentially Turkey could not assert jurisdiction on France. Turkey, however, was asserting jurisdiction over the French vessel, notwithstanding that international customary law, because when there is damage to one's vessels, especially when there can be criminal liability, then it is within the sovereign power of a state to make sure that it arrests individuals who might be responsible for criminal violations. In this case, Turkey was saying that because the French vessel had rammed into a Turkish vessel, there was a criminal liability in relation to a Turkish vessel. So that was the basis for the jurisdiction of Turkey. And Turkey was saying, we did not agree that there is only one international law on the subject. We never said that simply because there is an international law about which state, which ship, what state's flag is being flown in the ship. It doesn't mean that a concurrent state no longer has jurisdiction. And so the question was, given that there seems to be international law about the ship flying a certain flag, did it mean therefore that another state no longer had jurisdiction over a foreign vessel, even if that foreign vessel had then caused liability or had actually caused damage upon its own vessels? And Turkey was saying, we never agreed that we were surrendering our jurisdiction to enforce criminal liability on those who damage our own vessels. And the ruling of the Permanent Court of International Justice at the time in 1927 was that because international law, conventionally understood, is actually based on the consent of states, and there being no showing that Turkey and other states had agreed that simply because there is this corresponding customary international law about the flags of a vessel being flown, there was nothing to show that states had agreed that they no longer had jurisdiction or the power to enforce their own laws in relation to foreign vessels that damaged their own ships. Then in that case, the PCIJ said that it couldn't be said that Turkey had given up its right to assert its criminal jurisdiction over foreign vessels that had damaged its own vessels.
That's great, Manjo. Thank you very much. I'll get it now.
I'm going to have to apologize a bit about, asking you to repeat yourself. I actually have tinnitus right now. It's been bothering me for the past 5 days. For those who don't know what tinnitus is, that's when you have constant ringing in your ear. It's really severe. So not only can I not hear anything on my left ear, but there's a strong buzzing sound which interferes with my hearing on the right. So, I'm gonna have to apologize. Hopefully this disappears next week, but that's my limitation tonight. Okay, any other questions so far before we continue?
Manjo, I just want to confirm with the Lotus case, the high seas is international waters, is that right?
Sorry, the high seas is what?
The high seas is international waters. It would have been different if it was in Turkish waters. This issue wouldn't have been raised at all. Okay.
Absolutely, you're right. So that happened in the high seas. And as Ilonke pointed out, obviously if it happened in Turkish waters, then there would have been no question that given that Turkey has sovereignty over its territory, which includes its internal waters, there would have been no question that Turkey had jurisdiction. But the assertion of France was that because it happened on the high seas, customary international law, as understood, is that it has to be the state whose flag is being flown in a vessel that has criminal jurisdiction. But Turkey was saying, well, we never agreed to surrender our own power to exercise or enforce our own laws when damage is caused upon our own vessels. Okay, so we could proceed. Questions? Now, the one thing I need to point out is that in relation to the quizzes, what I would do is that during the tutorials of every week, I make sure to cover the quiz questions. Okay, not so much to actually provide an answer, but actually to go through it and have a discussion about what the correct answer might be. And of course, if you listen to the tutorial, if you actually attend the tutorial, you should be able to figure out what the answer is. All I'm saying is I will not, be very categorical saying that this is the correct answer, although it will be very apparent in the course of the tutorial that you know what the answer is. So there's an advantage to that. So the reason why I do that is that there seems to be there seems to be little point in coming up with a quiz and then not really providing an opportunity for a discussion about the concepts which are being assessed in a quiz. So that's what I do. And given the fact that it is, the recordings are actually accessible to all, then, to my mind, that it doesn't mean that there's an unfair advantage to anyone. And my hope really is that by joining the tutorials, or at least listening to the recording, students have a better chance of getting good scores, mainly because of good marks. Because as I said in my first email, 1 mark can make a difference between a pass and a fail. And it has happened many times, believe me. And it could be a difference between a high distinction and a distinction. So every single mark ought to count. Okay, so let's begin with the discussion question 1. Can I ask, especially because it's so difficult for me to be saying something, it interferes with my hearing. Can I just get somebody to volunteer to read the first question, if that's okay? Just read it, and then we will, try to discuss the answer together. Can I have a volunteer?
Yeah, I'll have a go.
Oh, thank you. Very good.
So let's just read it out, hey?
Yeah, read it. Just read it.
Kandoma and Rutamu are 2 neighbouring coastal states along which the River Hope runs. Hope is densely populated by a rare fish that is of high commercial value. From time immemorial, both states have fished in this river without any problem. But due to the narrowness of the river, the states developed a system whereby whenever one state was fishing, the other would wait a distance away until the first had left. On one particular occasion, a vessel from Kandoma was fishing when a vessel from Rutamu approached. The latter vessel refused to halt. Instead, it progressed until it got entangled at the mouth of the River Hope. Unaware, the captain of the Kandoman vessel collided with the Rutamuan vessel, killing 3 members of his crew, although there were no casualties aboard the Rutamuan vessel. When the Rutamuan vessel reached Kandoman shores, the Kandoman Revolutionary Guard promptly arrested the vessel's captain for trial in Kandoma. Rutamu objected to this proposed trial and claimed, in objection to Kandoma, that there was no breach of any waiting custom between it and Kandoma. Rutamu also claimed that it actually objected once to that stupid culture by writing to Kandoma, advised the parties.
Okay, very good. Thank you, Tamara. What do you think? The question is, is there an international custom? Is there international customary law pertaining to the practice of waiting, at least between Kandoma and Rutamu? So is there regional customary international law pertaining to waiting between Kandoma and Rutamu, especially because they seem to have practiced it for a long time?
Sorry, can I just have a go at that one?
Yes, Harry, go ahead.
Yeah. So if we go back to the Lotus case, so the sorry, where are we here? I'm just reading back down to it. The custom is there because they did the waiting, and although they claim that they objected to it in writing, Kandoma never agreed to let go of that right.
Okay.
Like with Turkey, how they never agreed to, they never consented to giving away their right of jurisdiction.
Okay.
When the vessel hit theirs.
Yep.
So Kandoma never consented to going away with that custom.
Let's assume, Harry, that Kandoma actually agreed to that particular custom. And let's assume that both parties, because in the facts here, I kind of said that they did agree, that there had been an objection on the part of Kandoma. Let's assume that there has been a general practice by both Kandoma and Rutamu to observe the practice of waiting. And they've been consistently, observing that practice. Would it mean, therefore, that there is regional international customary law?
Oh, that was what I was saying, yeah. Except that at the end there where you've got Rutamu claimed that they objected to it once.
Ah, okay.
Is that where, because Kandoma didn't consent to that it would still be in place?
Let's assume. So let's just remove that part, okay?
Yeah. So I was assuming that the custom was still in place because they never consented to, they never gave away their right to that custom.
Oh, very good. So you're right. So Harry is pointing out that because Kandoma had never agreed to that custom or to that practice, then it isn't a source of binding international legal obligation. Now, but let's assume that there seems to be kind of consent or agreement on the part of Kandoma to actually observe the waiting custom. And in fact, Kandoma and Rutamu have been observing that practice for a long, long time, consistently. So let's assume that there has been consistent practice between Kandoma and Rutamu in relation to waiting.
Manjo, with that one, the fact that Rutamu didn't actually, they still observed the custom, even though they had wrote to Kandoma and said, we don't believe in it.
Mm-hmm.
They still observed the custom, so it couldn't have been broken, really. This was the first time somebody hadn't observed it.
Okay. So the question I really have is whether or not there is customary international law between Kandoma and Rutamu in relation to waiting, to the waiting custom, assuming that there is consistent practice by both states.
Manjo, can you hear me?
I could hear you. Who's that?
Jamie.
Jamie, yes.
So what I was reading earlier about international custom was that it didn't just have to be, there had to be a general practice of the states that was consistent, but it also had to have a sense of legal obligation. The way I read it was,
that's right,
without the other one or the other, like it had to be both. It couldn't just be one.
So Jamie is correct. For there to be customary international law in relation to a particular practice, not only must there have been general and consistent practice by states, but more importantly, the states must believe that what the practice they're doing is actually part of a legal obligation. They're doing it not because it's simply a matter of usage or habit or custom, but because they think it is a legal obligation on their part. So in the absence of that opinio juris, in the absence of that legal belief that what they are doing, the practice is that they are doing is actually part of a legal obligation, then the practice cannot become customary international law. So those two things must be there. There has to be practice that is general and consistent, but at the same time, there has to be opinio juris, as pointed out correctly by Jamie, which is that the practice is actually accepted as law and considered to be legally obligatory by the parties. Okay, now, the other question I have is, assuming that, so this is kind of moving a bit away from the facts, okay, but kind of staying there still. Let's assume that there is a practice between Kandoma and Rutamu in relation to waiting, and let's assume that that practice has been generally and consistently observed by both states, and at the same time, both states act in relation to this practice out of a sense that it is law, out of a sense that it is a legal obligation. Okay, so we can argue that there seems to be general international customary law in relation to waiting. The question is, when we speak of customary international law, does it have to be general customary international law in the sense that it applies to all states, or can there be customary international law in relation only to 2 states, or in relation to only a few states within a region?
It can be regional, and it can only be with 2 states. It's particular customary practice and customary international law.
Very good. So PIDA is correct. That is very good. It is possible to have regional customary international law, which binds states within a region. It could even just be a bilateral customary international law. You can also have general international customary law that applies to all states. Now, we had earlier said, and we know that conventionally, we know that international law is developed out of an agreement among states. So there has to be an agreement among states. There has to be consent. The question is, can there be general customary international law when not all states agree to a particular practice? So let's assume that there is a consistent practice by many states, most states even, okay? And let's assume that most states undertake this practice consistently and generally because they believe that it is legally obligatory upon them, that it is accepted as law. The question is, does that particular practice bind states that never agreed to the custom? In other words, is there a requirement? In other words, the question is, for there to be general customary international law, is it a requirement that there has to be unanimity in practice among the states? Or is it sufficient to say that a majority of states have agreed that a particular custom is generally accepted and it's consistent in practice, but at the same time, it is accepted generally by most states to be legally binding? So is there a requirement of unanimity, or is it sufficient that there is a majority practice which is considered to be binding by most states? So from Ernest, no, very good. From majority, no. What do the others think? From Ilionka, like Japan hunting whales. Ilionka, can you just explain to us about the Japan hunting, the Japanese vessels hunting whales for their so-called scientific experiments. What is this all about for those who might be unfamiliar with it?
I was just thinking that most of the world is against it, yet Japan continues with it. So is it a case with them where they didn't actually sign up to a customary, or sign up to it, and therefore they can still carry on doing it? Would it be something similar to that as an example? I'm just wondering.
Very good. I'll get back to that because that raises, Ilionka's raised a very important point. She was actually saying, what if, there is no treaty? What if there is no convention that has been signed between states? Does it mean that there is no legally binding obligation? In other words, what's the difference between a treaty obligation and an obligation under general customary international law?
Manjo.
Who was that?
Jamie.
Jamie, yes.
So in relation to whether customary rules are binding on all states if they haven't agreed to it, there is the persistent objector rule.
Okay. Very good. Now, assuming that there is no such thing at the moment of the persistent objector rule, and let's assume that some states have simply not really been practicing it because they're not involved in it, but they've not objected. In other words, you know how it is, right? There are certain states that are not really involved in the practice because to them it's actually irrelevant, and then at some point it becomes, it might affect them. So let's assume that you have a state which hasn't really been practicing a particular practice, but it hasn't objected in any event to the practice being undertaken by most states which believe that that practice is actually legally obligatory. The question is, does that practice bind a state which has not persistently objected to the practice? So that was the basic question I was asking. Okay, from Marjorie, she's raised the recent question. Customary laws are accepted to be an international principle. I'll get back to that in a short while. From Kayla, I would think that if most are doing it and are acting as though they would be penalized if they do, then it does become customary. Very good, Kayla. But the question I was asking is, does it bind as well those states that never practiced it in the first place and never objected to the practice in the first place, and who never saw that the practice was legally obligatory in the first place? Or does that particular practice only bind? So in other words, a particular practice, does that become general international customary? Does that become general customary international law only when there is a unanimity of practice among all states? Or can a practice become general customary international law on the basis the practice of a majority of states who believe that the practice is actually part of international law? That was the question. What do you think?
Can I give it a go?
Is that Marjorie?
Yes.
Yes, go ahead, Marjorie.
From my reading, I'm understanding that customary laws is one of the sources of an international laws.
Very
Therefore,
good.
if most states, I guess my answer to the question is yes, it will bind those states who are not, who have, what's the word?
Even if they've actually not been practicing it.
Yes. So my guess is that they would, it would still bind them because one of the sources of international law are customary laws. Therefore, if, say, in conflict and the international court justice has to, I'm sorry, I'm very lost.
That's all right. So Marjorie is actually correct. So when you speak of general customary international law, there is no requirement that all states must be must actually undertake general and consistent practice, and that they all agree that that particular practice is legally binding. It is sufficient that a majority of states believe in a practice to be legally binding, and that will lead to the development of general customary international law. It will bind everyone, except, as pointed out by Jamie, except those states that have persistently and consistently objected to the practice being part of customary international law. So for there to be customary international law, it is sufficient that there is a practice that is observed by a majority of the states, and the majority of states believe that the practice is actually legally binding upon them. So that is the correct answer there. Now, there was a point, an important point posed by Leonka earlier, and that was, if you look at for those of you who might be familiar with the problem with the whaling, Japan oftentimes, well, every year has a lot of vessels, fishing vessels, that go to the high seas, and Japan labels these vessels as vessels being brought out for the purpose of scientific studies, and they how do you call that? They capture whales and they kill them for the purpose of advancing science. Now, the question of Ilionka was that there seems to be customary international law in that regard, in the sense that most states do not try to kill whales at all. And there seems to be a consistent practice among all states except for Japan. And the question, therefore, is, given that there is no treaty, there is no multilateral treaty or a treaty that is binding upon most states in relation to international whaling, could there be potentially customary international law against the practice of capturing and killing whales? Now,
I'm going to throw a spanner in the works here. There is actually a convention.
Okay, go on, Peter.
For, the International Whaling Convention.
Oh, very good.
And it is, which I think Japan is part of.
Yeah.
And it voted last year not to that Japan were only allowed a certain quota for scientific whaling, and that's what they get. But
okay.
Even so, the countries, the states that are against the whaling and a party to that convention actually put pressure onto put pressure on Japan not to go and get their scientific allowance.
Okay, very good. Thank you, Peter, for that information. So it's not going to be part of our unit to actually examine specific conventions or treaties between states. We're not going to get into that because there are too many treaties to be examined, and so we're going to be looking at the broad principles behind treaty obligations, but not examining specific treaties themselves. So that's very helpful, Peter, to know. Thank you. Okay, so from Emma, the issue was that Japan seemed to have taken more than their agreement in relation to the quota. Can I just ask a question there? Let's assume that Japan is actually a party to that convention against international whaling. But let's assume that Japan is saying that it is not in breach of its legal obligation under the convention because it doesn't, while it may be a party, it has no obligation to actually observe the convention in good faith, to actually fulfill its obligations in good faith. And it is saying, there's nothing in let's assume that Japan is saying that there's nothing in the treaty which says that the parties to the convention must act in good faith in the fulfillment of their legal obligations. The question is Japan correct? So let me repeat the question. Let's assume that Japan is in fact a party to a convention against international whaling. That particular convention, however, does not. So this is hypothetical. I don't really know. I haven't seen the convention, but let's assume that the convention does not have a provision which requires that the parties must fulfill their obligations under the convention in good faith. And it is now for this reason that Japan is saying that while it is true that it is a party to the convention, it has no legal obligation under international law to fulfill its obligations under the convention in good faith. So it can act in bad faith.
Yeah, Manjo, wouldn't you take that as an implied clause to act in good faith?
Mm-hmm. Okay.
So, well, considering what they're making, the international community's making the decision based on the having not read the treaty and all the prefacing information, depending on what the prefacing information says in the preamble, for conservation, wouldn't it then be an implied clause that acting and following the treaty within good faith in order to maintain the international norm?
Good point. The question I ask, however, is that conventionally, if you examine treaty obligations are usually expressed because, as we said, conventionally, when you speak of conventions and treaties, the obligations based on treaties and conventions are based on the consent of parties. So if they did not expressly consent to a particular treaty obligation, such as the obligation to act in good faith, how can then it be said that a party is bound to a principle such as to act in good faith if it is not purposely or deliberately included in a particular convention? I mean, remember, principles of good faith, principles of estoppel, and those things are understood in domestic legal systems. Are we now saying that we transport various legal principles in various domestic legal systems into international conventions, even in the absence of a lack of agreement from the parties to a convention? That can be quite dangerous, don't you think? Who is to know, what exactly, why would principles of good faith get into a treaty obligation if the parties have not agreed to it, given the fact that as far as treaty obligations are concerned, treaty obligations must be expressed for them to be binding. Given the nature in international law, the treaty obligations are based on the consent of states. What do you think, Jack? Or what do the others think?
Yeah, I think that's it. That's very interesting. That it makes sense, as you could see why, because so then states don't start arbitrarily deciding what is good for another country. But also on the flip side, very interesting there is that they don't make provisions, and it doesn't future-proof, for lack of a better term, the treaty. So if you looked, for example, if we examined the treaty of surrounding use of weapons of mass destruction, etc., if they only specifically stated weapons with, for example, mustard gas, Cyclone B, etc., and then some very bright spark in a very bad place decides to invent a particularly horrifying weapons of mass destruction, does that now become hey, we haven't said you can't use it, so go ahead?
That's a good point that Jack actually pointed out, because oftentimes parties to conventions deliberately omit certain things because they don't want to be bound by it. Correct? So there's the danger if you now implicitly try to impose obligations on the parties when they never agree to it, or in fact, when they purposely refused for particular provisions to be in a treaty because they don't want it. And for you, therefore, to kind of transplant certain principles in domestic legal systems as part of a treaty can be problematic. So what do you think? Is there such a thing as a principle of good faith that should be considered to be implicitly part of every treaty obligation, even if it's not said, even if it's not written down expressly? What do you think?
I would say that yes, there should be there should be at least an some implied good faith as to ratify the treaty. Otherwise, diplomacy in general would realistically start breaking down, and no one state could be held realistically to their word.
But what's your basis for saying that, Jack? What's the source of international law? I mean,
Oh, as in saying that no, there's no source at the moment for it, but as in perfect world would be the sort of the optimal solution.
Okay. There are actually three main sources of international law. We've talked about convention. We've talked about general customary international law as evidence of the practice, consistent practice of states, considering the practice to be legally binding. But there is a third source of international law. What is that? There is a third source of international law. What is that? Can somebody help us out here? And this is an important point.
Judicial decisions and teachings.
Okay, that's the fourth one, subsidiary source of international law.
General principles of law recognized by civilized nations.
So from Faye and pointed out by Ilionka and Marjorie, there is a third source of international law, and that these are the general principles of law recognized by civilized nations. And when you speak of general principles of law recognized by civilized nations, what this actually means is that there are certain legal principles found in domestic legal systems that then are considered to be recognized by most civilized nations so that they become part of international law. And the principle that one must act in good faith in the performance of legal obligations is in fact one of the general principles of international law. So when you speak of treaty obligations, it is implicit in treaty obligations, and this was the point that Jack was pointing out, it is implicit in treaty obligations that the obligations in a treaty must be fulfilled in good faith. And that implicit legal obligation is a result of general principles of law recognized by civilized nations. From Fair, who defines for the civilized? That's right. The general view is that every single state that is essentially part of the United Nations, they are civilized. So this is not the kind of conception we have that, you know, there are some states, first world countries, they're civilized, the rest of the world are not. The assumption is if you're part of the international community, especially if you're part of the United Nations, you have to be a civilized state. So that is just a parlance that they've been using, you know, when they put up the International Court of Justice. But so in general, you know, it's assumed that every state is part of a civilized nation. It's among the civilized nations of the world. Okay, it's 7:44. I'd like to jump for now. There are actually I've got 5 questions here. I'd just like to move to the quiz, mainly because I don't want to miss this, if that's all right, and then we'll backtrack later on. Can I get someone to read this particular discussion question, because this is the quiz question? Can I get somebody to read the question for us?
I'll read it, Manjo.
Yes.
In the 1980s, over 128 states, an overwhelming number of states of the world community, signed a landmark multilateral treaty that prohibited the dumping of hazardous waste by ships in the high seas. In time, more states, including those that were not signatories to the multilateral treaty, respected this practice and prohibited the ships that flew their respective flags from dumping hazardous waste in the high sea. Many states, however, continued to dump hazardous waste in the high seas. In 2013, it was discovered that a naval ships of the state of San Diego were dumping hazardous waste in the high seas. The ambassador of the state of San Diego was summoned by the Foreign Affairs Secretary of the state of Marietta in order to complain about the dumping of hazardous waste in the high seas by ships flying the flag of the state of San Diego, which, according to the Foreign Affairs Secretary of the state of Marietta, was a violation of international law. The state of San Diego is not a signatory to the multilateral treaty that prohibited the dumping of hazardous waste in the high seas by ships.
Very good. Can you continue reading the answers here, the potential answers, Peter?
Yep, sure can.
Thank you.
Okay. Which of the following statements is the most correct? The state of San Diego is bound by the multilateral treaty that prohibits prohibited the dumping of the hazardous waste by ships in the high seas, even though Sandorio wasn't a party to it because of its overwhelming acceptance by the world community. The state of Sandorio has violated international law because the prohibition against dumping of hazardous waste by ships in the high seas has become part of customary international law. The state of Sandorio is not bound by the multilateral treaty that prohibited the dumping of the hazardous waste by ships in the high sea. Following the opinion of a well-respected professor of international law from Yale University that the dumping of hazardous waste by ships in the high seas is now part of international law, the state of Sandorio has violated international law. All of the above answers are wrong.
Thank you. Can I just ask everyone, if it's possible, can you just try to answer discussion question 4? Put a letter in the chat box as to what you think is the most correct answer in relation to the question. So for Marjorie, A, B, and C, well, what does that mean, Marjorie? You're meant to only choose one. So most are saying C, some are saying B. Okay. I now have about, is it 3 or 4 saying B? Most seem to be saying C. Okay. Let's just go back to the facts a bit, just to be able to clarify this. We will note that more states who are not signatories to the multilateral treaty have been observing the practice, but many states continued to dump hazardous waste in the high seas. So many seem to be doing it still. And at the same time, we know that the state of Sandorio is not a signatory to the multilateral treaty. So those are some crucial facts there. So what do you think? Is it B or C? These seem to be just the potential answers here from what the class is saying.
Yeah, Manjo, I'd probably say C, just because that only parties to treaties are bound by it. As you've put in the lecture notes, that the principle was recognised in the decision in Federal Republic of Germany and the Netherlands, where it ruled that only the 58 Geneva Convention on the continental shelf applied only to the parties to the convention.
Okay, I cannot disagree with that. That's correct. The question, however, Jack, is this. Can it be claimed that the dumping of hazardous waste by ships has now become general customary international law? That's the other point there. And
no, because
yes?
some states still, no, because some states are still doing it and have continued to do it.
So there doesn't seem to be general and consistent practice, and there is obviously no showing that they feel that doing it is actually a legal obligation. Very good. Okay, so I'm not going to tell you what the answer is, but I think it should be apparent. Very good. So let's backtrack. I'm going to leave that now. I think you know what the answer is. I'm going to leave that now. So this one should be easy. Discussion question 2. Can somebody read discussion question 2 for us? Yes, Faye.
Okay. The ambassador of Nirvana to the state of Guanalan was summoned by the state of Guanalan Secretary of Foreign Affairs to complain about the failure of the ambassador to bow before the king of Guanalan during a diplomatic meeting. The Guanalan's SFA claims that there is a consistent practice among states that people, including diplomats, should bow before monarchs and kings. Hence, he claims that there is a customary international law on the matter. Assuming that there is such a consistent state practice, would the SFA be correct?
Okay. So let's assume that there is a consistent practice among states to bow before monarchs and kings. I think even in Australia, we do that. I think. Let's assume that, everybody does it. Would it be correct for the SFA, the Secretary of Foreign Affairs of Guanalan, to then say that there is customary international law that requires a practice that, even diplomats must bow before monarchs and kings? What do you think? What's the rule again about customary international law? Peter, you have to unmute yourself. I can't see others. The others. Sorry, I've only see 5 students on my screen. The others are not visible. So if you wanted to say something, I'm not going to be able to see you. You're going to have to either raise your hand using one of the buttons on Zoom or unmute yourself, because the only people I see on my screen, somehow, I don't know why, would be Peter, Jamie, Jack, Marjorie, and Faye at the moment. Yeah, Peter, what did you want to say?
Yeah, I reckon it has become international, you know, basically international law because everybody does it.
Aha.
Wouldn't that be the same thing that applies to the Queen of England? Everybody curtsies or bows. Is that along the same lines?
Uh-huh. So what do you think? Marjorie is asking a question, which is the same thing as Jamie was pointing out. But is bowing to a king or monarch obligatory, though? When people do it, are they doing it simply because it seems to be a matter of practice and usage? Or are they doing it because it's a matter of usage, but at the same time, they're doing it because they feel they're legally bound to do it? What is the rule about customary international law?
I think in this case, they're just doing it as a practice, not because there's any legal reason there.
Right. Ilyonka here is making a very important point. No, it is not law. It is just cultural custom and observance. Okay, so there are many things that go on internationally. You know, people don't stick out their tongues. People don't, they probably shake their hands. You know what I mean? People don't say bad things. You know, they don't become rude. I was thinking about what happened to Donald Trump during the armistice event a few days ago. What was that about? You know, when people are meant to be kind of polite to each other, assuming that diplomats are meant to be polite to each other, does that mean that politeness is part of customary international law? Right? That's the question. From Brad Fittler in this 90 saying, good day mate to the royals from Harry. Okay. So what's the requirement here? When does a practice become customary international law? Just so we don't forget. What's the requirement there? There are twin requirements. And these have been pointed out already by Jamie, by Marjorie, and by Ilyonka. Can somebody summarize for us again the rule about general customary international law? Yes, very good. So from Tamara and Marjorie, there has to be consistent practice, and that practice must be undertaken because they feel it is a legal obligation. Thank you, Ilyonka. Very good. So those are the twin requirements. So going back to the question we had in relation to the quiz, the question, because Shante was raising it, it wasn't clear to Shante what the correct answer is. The point is, for there to be for a practice to be considered part of customary international law, there has to be practice. That's the first one. And the practice has to be consistent. It has to be general. So if the practice is not consistent, so perhaps many are not following it, you cannot say that there is general and consistent practice. So when there is a practice in the international sphere by states, and that practice is not general, meaning not many are doing it, and it is not consistent, in other words, some are doing it sometimes they don't, then you cannot say that that practice can ever evolve into general customary international law. So that's a first point, remember? So you've got an objective standard because you can see it in the behavior of the states, but there is actually also a subjective element in that there has to be a belief that the practice being undertaken is being undertaken because it is a legal obligation. So I would hope that, the answer to discussion question 4 would be quite clear. Okay, but I'm not gonna provide a clear answer there for the moment. Okay. Discussion question 3. Can somebody read discussion question 3 for us? Can I get a volunteer? Jamie?
Hey, Manjo, not for reading question 3, but I just wanted to point out to everyone, when they load their quiz, the answers reorder themselves every time. So don't everyone go, oh, we know what the answer was tonight.
Right.
And jump on and click the letter without reading.
That's true. So the quiz questions, you know, they're meant to shuffle. So don't think about what the answer is here, whether it's A, B, C, or D, or E, okay? Be sure you know what the actual answer is. So thanks, Jamie, for pointing that out, because I purposely made them, you know, shuffle.
And
So
Manjo,
Emma.
Manjo, it's Emma. Just on that, is it true that you get 2 attempts? Because my screen clicked itself out of it and I've got 2 attempts to the same quiz question. Is that meant to happen?
I'm not sure how it works, but I actually allow students to have 2 attempts. The problem, however, with the 2 attempts is that even when you make a first attempt, you don't really know whether your answer is correct or not.
Yeah, that's true. So, but the question was the same, yes, but the order would have changed. Is that correct?
It would have changed. It would have changed. You're right.
Okay. Well, I hope I got it right the first time, because I will have got it wrong the second time.
So you have 2 goals. However, even if you do, you know, even if you answer the first time, you really don't know what the answer is. So I'm not sure if it makes sense actually to have, you know, 2 attempts, but I put it in anyway. But perhaps, you know, somebody was excited and felt that, you know, the person was ready to answer it the first time. And then that person listened to the tutorial or was at a tutorial and said, oops, I may have made a mistake. In that case, this would be a good time for that person to revisit the quiz and, you know, maybe do another attempt. So in that sense, that would be helpful, I think. Okay, can I just ask, before we end tonight's session, can I just get somebody to read discussion question 3? Yeah, you could. You certainly could, Ilyonka. So if you've if you've answered it the first time, you felt like you probably answered wrong, you do it the second time, which should be permitted. Yeah. Okay, can I get somebody to read question 3 for us, please? Okay, can you volunteer again?
Okay. The Paris Agreement on Climate Change entered into force on 4th November 2016 upon its ratification by 109 of the 197 parties to the United Nations Framework Convention on Climate Change. Under the agreement, the parties commit to reduce the respective greenhouse gas emissions according to specified targets. Although the state of Catalonia is not a party to the Paris Agreement, it has increasingly been under pressure to reduce its own greenhouse gas emissions. Considering that perhaps only less than 3% of states of the world are not yet parties to the Paris Agreement, it is now claimed by some that the duty to reduce greenhouse gas emissions has now attained the status of customary international law and binds the state of Catalonia, advise the state of Catalonia on the matter.
Okay. I'm hoping that everybody's aware about the United Nations Framework Convention on Climate Change, right? I'm hoping everyone knows about that. There seems to be a general agreement among states, without exception, that that states have an obligation to reduce their greenhouse gas emissions. Okay, I think there is a general agreement on states, and I think that, there is also a belief on the part of the states that it is a legal obligation on their part to actually reduce the greenhouse gas emissions. The question is there now, in fact, a general customary international law about greenhouse gas emissions? Do you suppose that there is now a general customary international law requiring states, as part of a international legal obligation, to bring down their greenhouse gas emissions? So when you say greenhouse gas emissions, they're called anthropogenic greenhouse gas emissions. They're anthropogenic because these are greenhouse gas emissions resulting from man's activities. Okay, see you soon, Jamie. Thanks. What do you think? Is there a general customary international law? Yes or no? Can somebody say yes or no? Tomorrow, yes. What do the others think? Give it a guess. Yes for Marjorie. Ah, yes. Okay. Uh-huh. Okay. But the question is, what exactly is the legal obligation? The problem is there are targets. There are specified targets. How do we know what the targets are? So it's one thing, therefore, to say that there seems to be general practice of states to try to bring down greenhouse gas emissions, and in fact that states feel they have a legal obligation to bring it down. The problem we have in international law is that we do not know the content, the specific content of the legal obligation in international law. What exactly is the specified target? Because in fact, when you look at the United Nations Framework Convention on Climate Change, there are actually different targets according to the state. So there, I think there's 3 categories of states, and some do so on a how do they call it, the best efforts basis. Some make clear binding legal obligations. And as far as the United States is concerned, I think the United States withdrew its initial desire to become a party to the convention. So I'm not sure if the United States is even a party, meaning it is bound, legally bound by the United Nations Framework Convention on Climate Change.
Manjo, the United States are still part of the framework, but they've only withdrawn from the Paris Accords.
Ah, okay. And the Paris Accords would reflect the specific targets. Would that be correct?
Yeah, that was my understanding of it.
Yeah. So it's one thing for so in other words, there seem to be 2 parts to the Framework Convention. One would be to say that we want to bring down our greenhouse gas emissions. That's a general broad obligation. But the specific targets, the specific obligations are contained in a different accord, in a different convention. And it is that different convention. I think you've got the Kyoto Protocol and whatever, the Paris Accord is part of a JAC. These are the ones which set specific targets. So without knowing what the specific targets are, you don't really know the content of general customary international law. So in relation, therefore, to the greenhouse gas emissions, even assuming that seems to be become part of general customary international law in conjunction with treaty obligations, the specific content of the general customary international law is still not clear because there is no specific target common to all. Okay, so the answer here would be, if I were the one to advise the state of Catalonia, I would say that there is no customary international law binding on states as to specific targets in relation to greenhouse gas emissions. From Emma, yes, but doesn't that mean they're bound by it if they aren't observing it? Bound by the convention or bound by international custom? Because it is possible that specific obligations arise both from treaty obligations as well as from general customary international law. They can be present at the same time. So from Emma, by the convention, yeah. So yes, they're bound by the convention. However, their specific legal obligation in terms of the specific targets is determined, it would appear, by another convention. So they may be bound by the general obligation where they say they want to bring it down, but what those specific targets are actually embodied and incorporated in another convention, and potentially another state, although a party, meaning bound by a convention, the United Nations Framework Convention on Climate Change, may then not have become a party to the specific targets as found or embodied in another treaty or convention. Okay, it's 8:05. I think it's a good time for us to end here. We've covered the 4 questions. So from Ilyanka, so treaty convention signatories are bound by the terms of the convention, and non-signatories will be bound when it becomes customary international law. So that's right. So it is possible that what initially starts as an obligation under a convention can, through time, become customary international law, which means, therefore, that even a state which was not even a party to a convention can be bound by the content of that convention when the practice within that convention becomes part of customary international law. So was that distinction quite clear? Very good point, Ilyanka. Was that convention very clear? So many parts of international law become customary international, actually coming from treaty obligations. But remember, the treaty obligations only bind those who are parties to it. But in time, there may be non-parties to a convention who become bound by international law because that particular practice initially embodied in a convention becomes part of customary international law, which means that when there is a consistent general practice among a majority of states, that particular practice, especially when it's coupled with the belief that it is a legal obligation in international law, binds all states as well, who may not even be parties initially to a convention. Okay, so do you have a modern example of this? Okay, so let's speak, for example, of the convention on the treatment of prisoners of war. They should be very familiar with Jack, which we're going to be examining later on. So you have the how do you call that, Jack? You have the conventions after World War II, or even during World War II, which prohibits that requires the treatment, the civilized treatment of prisoners of war.
An article, it was the articles under the Geneva Conventions. I think it was Article 4.
Very good. Now, you will recall that a lot of states are new. There are probably about 30% of states of the world community now were never part of the United Nations then, and never were parties to the Geneva Convention. Correct, Jack? Correct?
Yes.
They're new. The question is, are these new states, because they were never parties, assuming they never adhered or acceded to the Geneva Convention, are they bound by the terms of the Geneva Convention? For example, in relation to the treatment of prisoners of war. What do you think?
No, because the United States are not signatories to certain parts of the Geneva Convention, and still routinely do things that are within the Geneva Convention.
That's an interesting point. I would argue, and I'll go back to the issue of the United States, I would argue that there is now general customary international law about the treatment of prisoners of war, that they have to be treated civilly, in a very civilized manner. There is a general customary international law in that regard. Now, the United States, therefore, even if it may not have been a signatory, and I don't know about that, because that's a factual matter, would have been bound under the rules of general customary international law. It's another issue altogether about enforcement, however. And I think in relation to the United States, the question is not so much whether that particular legal obligation exists in international law, but whether or not it can in fact be enforced against another state. That is a different question. We're not talking about enforcement at this time, because a state, for example, such as China, may violate the norms of international law. But what can you do about it? For example, in relation to the South China Sea. These are two things. So let us make a distinction between whether or not there is international law in particular in relation to a particular subject. And let's distinguish it from enforcement, because potentially, yes, there is a legal obligation in international law. However, it cannot be enforced. That's another thing. The United States, it's difficult to enforce. Like, the United States employing torture, for example, that could be, a lot of states are saying that's a breach of international law. But it cannot be enforced against the United States. Who can enforce it against the United States? No one. Okay. So this would be a good time. Anything else before we end tonight's sessions? From Ilonka. So if you're a signatory to a party, then it can be enforced, but customary cannot. Ilonka, what did you mean by that?
Okay, so if you're a signatory to a treaty or a convention and you go against it, then it can be enforced against you?
Yes.
But if those treaty agreements have now veered into becoming customary international law, that's not enforceable. Is that right?
It would be enforceable, because if the content of a treaty obligation has evolved into general customary international law, then it becomes binding even upon non-parties to the original convention. It becomes binding on all states. But the question, there's a difference between what is binding and enforcing a binding legal obligation. Our problem is enforcement. We're not there yet. We're not talking about enforcement. Okay. We're going to talk about it later on. But for now, we're just talking about, is there a legal obligation? And then we'll ask later on, how do we enforce it? We'll discuss that later on. Okay. So we're good. Okay. So thank you very much, everyone. And, enjoy your night. And I'll see you again next week. Good night. Bye. Thanks, Fair. Thanks, Emma. Good night.